Hey guys, good morning in this case. So I'm going to start doing for the shorter pieces of content when we're not watching full trials, but I do want to go live and let the chat be able to, be part of the conversation. I'm going to start calling these short, kind of unplanned lives, what in the, right? Because it could be in the morning, it could be in the evening that we pop live. And the subject matter is going to be surprising decisions, surprising motions, viral topics, things that are just short stories in the law nerd and law adjacent space that just kind of make you go, what? So today to kick this off, the case is Oregon v. Ian Cranston. So it was a new case to me. I only discovered it in the post conviction space. But yesterday, the Oregon Court of Appeals issued their decision to reverse the conviction. He was convicted of manslaughter, one of the lesser counts, and remand the whole thing back to the trial court. So we're going to see what happens. Since I didn't go live yesterday, I also took the time to find the oral arguments. So we're going to hear the uh, representation, the counsel for Ian Cranston, make the argument that the court failed by failing to give the jury an instruction that Oregon is not a duty to retreat state. There is no duty to retreat in Oregon. So we're going to see what happens with that. I think what was helpful for me, since I didn't know the case, we can actually look at the factual background quick, get a reading, get like the brief 411 of the actual incident from the appeal. So let me open that, and all links should be in the description for you guys. Do, 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 do. So what we'll do is we'll read the beginning half of the decision, which will just tell us the background on the case. We'll watch the oral arguments, and then we'll come back and we'll read the analysis. It's about 11 pages total for the decision, and I think like 28 minutes for the oral argument. So I think this will be a good conversation. And guys, if you are in a state that has duty to retreat or does not, let us know. Hey to Factual Lie. Hey to Mavka. Nurse Janice in the building. It has been a while. Candace is in the building as well. She's stuck in a meeting. Oh no, oh no. We've got to bring it out. Bring out the bushes. Good morning to Sapphire Ridge News, our friend and also a booming content creator, started on YouTube but now booming over on TikTok. Congratulations. Hey to Janice, good to see you. We've got Emma J in the building. Good morning, MJ. Good morning to David, Miss Candy. We've got Bama fan here. That's what's up. Let us know who you're a fan of. We've got Matt. Your name is short here. So now you're not Peter, you're just Max. And then Janet, good morning. So let's get this background over here. This was decided on October 29th, but it was published, the opinion was published yesterday, at least that I saw. And again, it's the state of Oregon, and Ian Mackenzie Cranston was the defendant at trial. This is a panel of 3 judges. We've got counsel for the appellant, so the defendant here, Lindsay Burrows. We're going to see her do the oral arguments. We've also got Jonathan Schilt, who we'll see, I think that was the same guy we'll see in oral arguments. And then we have the presiding judge, Kamens Tukey, the presiding judge, Kamens, and Jacquot. So here we go. The defendant is appealing from a judgment of conviction for first-degree manslaughter with a firearm. He was acquitted of the murder charges. So the jury found him guilty of the lesser of manslaughter with a firearm, first-degree assault, and unlawful use of a weapon. He was sentenced to 10 years, by the way. Jury trial. Defendant argues that the trial court erred when it refused to use his special jury instruction regarding the absence of a duty to retreat under Oregon self-defense law. We agree with defendant that, on this record, the trial court erred by not instructing the jury to that effect. Because the error was not harmless, we reverse and remand. We've got a footnote. Footnote bright and early. Our disposition obviates the need to address defendant's remaining 2 assignments of error. Now pin this. I hear a lot of attorneys, and I started to notice it now that they put me into paying attention to it. When several issues are raised during appeals and the court wants to reverse a decision, if they evaluate one enumeration of error and they decide, cool, this is enough to reverse and remand. We're going to stop there. We're not going to look at the other issues. Sometimes it seems like they let the court be at fault, or they let the trial counsel ineffective assistance of counsel claim be the deciding factor. And then they won't address things like arguments, enumerations of error involving prosecutorial misconduct. They'll just ignore that and they'll keep it moving and say, look, we don't need to look at that because we've already decided. So pin that footnote for oral arguments. We describe the evidence in the light most favorable to the proponent of the instruction, which would be the defendant at trial, to determine whether the record supported given the instruction. So they're looking at State v. Owen, 369 or 288, 290. They're giving this whole site here. Defendant went out for some drinks in downtown Bend. So again, we're in Oregon, with his fiance, Butler, and his friend, Smith. Defendant had a concealed handgun license and brought a gun with him. While the three were at a bar and Butler was waiting by herself in line for drinks, so this is the fiance, she was approached by B, a man whom she did not know. B complimented her on her looks and asked her what her name was. Butler showed B her engagement ring and told him that she was not interested, and B left. Later that evening, defendant Butler and Smith went outside the bar to smoke. Butler was approached by B again, who told her that she looked beautiful and asked for her name. Butler, this time along with defendant, told B that she was not interested and to move along. B and defendant began to argue when B, without warning, punched defendant in the head. Defendant took out a gun and yelled at B to go away. Smith tried to intervene, and B struck Smith in the face. At that point, so this is the friend of the fiance and the defendant. So now he gets punched in the face. At that point, approximately 30 seconds after the argument began, defendant fired a single stomach. That interaction was caught on several different recordings, including a video recording made by Butler on her cell phone. Defendant was charged with second-degree murder, first-degree manslaughter, second-degree manslaughter, first-degree assault, and 2 counts of unlawful use of a weapon, all with firearm enhancements. At trial, defendant did not dispute that he shot and killed B, but argued that he acted in self-defense or defense of others from what he reasonably believed to be an assault by B. The state, at several points during the trial, questioned why defendant did not just walk away. In response to that line of questioning, defendant, when it came time to instruct the jury, requested a special instruction stating that, under Oregon law, there is no duty to retreat before using deadly force in defense of self or others. We've got a second footnote. This says the special jury instruction read, Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. So this quote is exactly what the defendant requested as a jury instruction, and it was denied. It was denied. So the jury does not get this instruction. A defendant argued that the special instruction was necessary because the uniform instructions on self-defense do not mention the lack of duty to retreat, and given the prosecutor's questions and argument, the jury could be confused about whether defendant had such a duty. The court declined to give defendant's requested jury instruction, reasoning that the jury could consider whether defendant's decision not to retreat was reasonable under all the circumstances, and that the requested instruction, quote, misleads the jury into thinking that a person has no requirement to retreat. Now, pay attention. This is the trial court saying this. We're going to hear the state argue this during oral arguments. We're going to hear the 3 judges ask some questions about this sentiment here. So, court's decision, court said it misleads the jury into thinking that a person has no requirement to retreat. Now, again, this is Oregon, which has no duty to retreat. The jury found defendant guilty on all but the second-degree murder count, and this appeal followed. So let's get over to the oral arguments, guys. That is the background. I did pull up it's not a very good surveillance video and a timeline that was introduced at trial. We'll take a quick look at that, but let's do it after the oral arguments because unless the judges happen to see the news when it started, the appeals court isn't sitting there playing this video footage. So it would just be us looking beyond the appellate court's decision. So oral arguments, you guys. This court of appeals does all of their stuff online, which is awesome. I got us some captions last night. I put it on YouTube. That way we could have YouTube's captions. because you'll notice down here there's captions from the court, but I can't move them any higher. So let's get this going. And there's going to be two mouses. The one mouse is not me. The one mouse is whoever's running the court.
Hear ye. The Honorable Court of Appeals of the State of Oregon is now in session.
Good morning. Please be seated.
Hey, Amy. Hey, what the F? What the fair use? I like that.
4 cases we'll hear this morning. The first is A180204, State versus Cranston. We're ready for your argument when you're ready.
Good morning. Thank you, Your Honor. May it please the court, counsel Lindsay Burrows for defendant Ian Cranston. I intend to focus my limited time this morning on the first assignment of error regarding the duty to retreat instruction, or actually the lack of duty to retreat under Oregon law. I do think, though, that the Chitwood argument is strong and presents serious prosecutorial misconduct in this case. Obviously, this court has had plenty of opportunities to interpret Chitwood at this point. I'm more than happy to answer any questions that the court has regarding those issues. Because again, I think this case presents very serious prosecutorial misconduct that on its own warrants reversal, even in a plain error posture. But turning to the lack of duty to retreat, the trial court erred by refusing to give defendants requested instruction. The instruction was a correct statement of law, and it was needed to cover a necessary point of law that the uniform instructions did not otherwise address. The instruction was also necessary to prevent a risk of jury confusion in light of the state's evidence presented at trial, and then the way the state used that evidence in closing argument to specifically suggest that because there were other alternatives available, self-defense was unavailable to defendant.
Can you work us through the instruction in terms of what was requested, what the trial court gave, and then Sandoval and how it fits together?
Yes, certainly, Your Honor. So the requested instruction was Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. So the idea behind the instruction, the plain sort of text of the instruction, is that if the jury finds an alternative besides the use of force, that is not a basis for rejecting self-defense on its own. But the court also gave all of the uniform instructions on self-defense, which defendant requested, and those included the requirement under Oregon law that the state disprove beyond a reasonable doubt that the threat was imminent. And I think that is where the state's focus is. And that concern was squarely addressed by the uniform instruction that was requested and given. The trial court declined to give the instruction, reasoning essentially that there is a duty to retreat under Oregon law, which is plainly inconsistent with Sandoval. We can talk about that. And the court said that the jury could use whether there were alternatives available in the reasonableness of the self-defense calculation, which is exactly what Sandoval teaches is the wrong way to use this sort of evidence.
Doesn't the state say the proffered instruction was inconsistent with Sandoval? And so why is that not? Why aren't they right about that?
Right. So I think, Sandoval stands for the clear proposition that as a matter of law in Oregon, the legislature intended that a person be able to use force to meet a threat of force. That is in the deadly force context and in the non-deadly force context. And in Sandoval, I think the language of the opinion couldn't be clearer. The court says nothing in the wording of the self-defense statute, so the court actually cites the statute, just paraphrasing that part, suggests that persons who reasonably believe that another person is about to use deadly force against them must calculate whether it is possible to retreat from that threat before they use deadly force in self-defense. That's on page 512. So again, that is exactly what the defense counsel is asking the jury be instructed. And because the prosecutor inserted sort of the alternatives that were available, couldn't you have just walked away, Mr. Cranston? That became a hotly contested issue in the case and made the supplemental requested instruction necessary.
And there was a video and they played it several times, is that right?
Yes, Your Honor.
And counted seconds and things like that?
Yes.
So what the judge is asking here is the Lindsay Burrows, who's arguing on behalf of Ian Cranston, just made the point. I'm hidden. Just made the point that, this is not a duty to retreat state, and prosecution repeatedly during trial and in closing arguments, so through the way they questioned witnesses and in their closing arguments, made the argument that it was unreasonable for the defendant not to retreat. They kept pounding home this argument. And this judge is asking, didn't they, meaning the prosecution, they also kept playing this clip of the video, slowing it down, which is not what happens in a real-time decision-making process. You don't have a pause or a slow down or a rewind button, and saying over and over, counting the seconds. I think it was like a 30-second time gap where, someone gets punched in the face. I think the defendant gets punched in the face. We're going to read the timeline. He steps back. Somewhere in between there, the friend gets punched in the face, and then another 8 seconds passes, and pistol is withdrawn. He says something about having the pistol, and then he shoots the one time. So the judge here is, when considering whether something could be harmless error or not, well, if the prosecution's really beating the point home, playing it over, counting the seconds, arguing, making it a focal point of their closing argument, it's more likely that the judge will decide that it had an impact on the jury's decision making. So that's why she's getting the clarification.
Right. So, right, there was a video, wasn't, the clearest video. I think defendants, and when evaluating this sort of assignment of error, the court views the evidence in the light most favorable to the party who requested the instruction. Defendant testified that when he ultimately fired the gun, BW, the alleged victim, was at that moment about to swing and punch him again, as BW had done multiple times, had also punched Mr. Cranston's friend, and shoved, or there was some dispute, but in the light most favorable to defendant, his fiance as well. So this is an active threat situation. And what the Supreme Court case law teaches is that the legislature did not want someone to have to run through the list of possible alternatives when faced with a threat of serious physical injury or deadly force, which is exactly this circumstance.
So just refresh my memory. So the state says that, again, the instruction failed to capture the distinction between imminent and non-imminent threats. In the end, giving the instruction would have confused the jury. Why aren't they right about that?
Right, because
I wondered about it.
Yeah, thank you, Your Honor. Because imminence was always going to be required, and the jury was instructed that there had to be an imminent risk of serious physical injury constituting a felony or deadly force to defendant in order for self-defense to apply in the first place.
And I think this was such a sharp argument from Lindsay is, hey, imminence is a requirement of a self-defense or defense of others justification, regardless of whether or not you explicitly say the phrase no duty to retreat. Imminence is still something that has to be, the defense wants to raise, they want to claim as part of their affirmative defense. And then the prosecution has to get over that hurdle to show that there was no imminence. And that's the case whether or not the phrase no duty to retreat is uttered or not. And the prosecution, I guess, at the trial level argued to the court, and the trial court agreed that since they're arguing, it wasn't reasonable. It wasn't reasonable for you to wait there that long before pulling the trigger. That was enough for them to not give this instruction.
So what was missing from that imminence was required, there's no dispute. But what was missing from that is that if the jury did find that there was an imminent risk of serious physical injury to Mr. Cranston, it could not reject self-defense on the basis that Mr. Cranston could have just walked away, which again is exactly what the prosecutor was suggesting the jury find.
Can you clarify the record? It seems like there was a whole bunch of things going on. It wasn't just 30 dead seconds where he was not deciding what to do. There was, but first he hit Mr. Cranston, and then did he then hit Mr. Smith and push the girlfriend out of the way? Or
yes,
was that the order?
Yeah, the order is unprovoked. BW hits Mr. Cranston 2 times. Mr. Cranston is disoriented by that. His head feels fuzzy. He has experiences of serious physical injury at that point, pursuant to, again, the standard of review. Then BW hits Mr. Smith, his friend, also there. Mr. Cranston's fiance is,
Hey,
you know,
Keisha.
so concerned that she gets out her phone and starts filming like what is going on. And then BW pushes her and pushes the phone out of the way. And then as BW is attempting to swing again, Mr. Cranston does pull out his gun. And actually there is one important sort of thing in the middle, which is that Mr. Cranston does sort of brandish his firearm and sort of like a, look, you know, this is really serious. I'm going to protect myself, sort of, you know, putting BW on notice that deadly force is at issue. He does have a right to protect himself. And ultimately he does. And so for the jury to correctly decide self-defense and analyze the elements of that defense, it had to understand that Mr. Cranston had a right, and Sandoval says right under Oregon law, to meet a threat of force with force. He did not have to walk away, which is exactly what the state suggested. I think, you know, going back to Sandoval, one thing that I think the opinion makes very clear is that there is a necessity requirement in the self-defense statutes, and Sandoval takes that on directly. And Sandoval says that means that the jury has to evaluate the actual threat of force against the defendant, because what the legislature intended is that, again, when someone is facing a threat of serious physical injury or deadly force, they don't have to run through all the alternatives in this split-second determination. The jury's focus needs to be on defendant's belief as to the reasonableness of the threat of force against them, not on what other options were available. And that, I think, is the clear holding from Sandoval and what the legislature intended. The state relies on State versus Harriman, which we address in the reply brief. I think the facts, so one thing to note about Harriman, the court never says that the lack of duty to retreat requested instruction in that case was erroneous under law, which I think is what the state is suggesting in this case. So I think that's an important takeaway from Harriman. But also in Harriman, ultimately the court held that the facts in that case did not create a risk of jury confusion. So this case is just distinguishable on the facts because of the evidence that the state presented, because of the state's decision to repeatedly question Mr. Cranston on the stand about if he could have just walked away. And then again, the prosecutor's decision to initiate, like bring back that idea, draw the jury's attention to it during closing argument. So again, this was a disputed issue in the case in a way that Harriman just wasn't. And so, you know, in some cases, I think Harriman stands for the correct proposition of law that just giving the uniform instructions will be enough. But in a case like this, where the state has put at issue whether a defendant could have just walked away, there is a genuine risk of jury confusion. And that's why both the error is harmless and the trial court has to give the instruction.
Isn't harmless.
Questions? Thank you.
Now the state, attorneys for the state.
May it please the court. Good morning, Jonathan Schilt on behalf of the state, asking this court to affirm the trial court's judgment. So on the first assignment of error, I think we have a slight disagreement with defendant, and I don't know if the court can hear me. This is the first time I've been in the courtroom, and the speakers are weird. In this courtroom, in a while, the speakers are a little weird. We have a disagreement about how to interpret Sandoval, I think, and then certainly a disagreement how the jury would understand the proposed instruction. So let me start with Sandoval. It sounds like defendant agrees with the state's position that there is no duty to retreat only in situations where a defendant faces an imminent threat and has a reasonable belief that that threat is imminent and that the nature of that threat is of a particular degree. And I think, counsel read one quote from Sandoval. I think that probably what better captures it is when the court said that Oregon law does not require persons who reasonably believe that another person is about to use deadly force against them to calculate whether it is possible to retreat from that threat before they use deadly force in self-defense. And so the point is that when a person holds the requisite belief that there's an imminent threat of a certain degree, in that situation, the person has no duty to retreat. But what the court also recognized is in situations where there's not an imminent threat, or the defendant doesn't hold a reasonable belief that there's this imminent threat, then in fact the law does functionally impose a duty to retreat, because in that situation, a person cannot
Functionally.
use deadly force. Their only lawful options are.
So here's where we had Lindsey Burrows saying, hey, Sandoval says it's a right. And here we have the Assistant Attorney General arguing for the other party, for the state in this case, saying it acts functionally to say that one should retreat. There's a big difference in the verbiage there. Interesting freeze frame. This judge looks like she's in disbelief a little bit.
To retreat or do something else. And that's what the footnote in Sandoval is all about. It says if a particular danger is not imminent, a person who wishes to escape criminal liability may well be required to avoid the danger rather than seek it out. But in the only issue the court was considering in Sandoval was if a person who faces an imminent threat and holds the requisite reasonable belief, in that situation, do they have to run through the options of retreat? And that is not true. But in situations where a person doesn't face that imminent threat, or they do not hold a reasonable belief, the law functionally does impose a duty to retreat. And so when you...
So it seems like this whole time, though, there's either an imminent self-defense problem or an imminent defense of others issue, because it seems like one of them was imminently going to be a victim during this whole period of time. How does the law analyze that?
Well, the state's argument here is not that the evidence would not support a legally correct instruction on duty to retreat. It is that this instruction as given is overly broad, because what it tells the jury is that a person can use deadly force in self-defense or in defense of another person in essentially all circumstances or at all times, not just when the person has the requisite reasonable belief that there's an imminent threat. And so that's what's lacking here with this instruction. And what the defendant says is, no, the jury would have understood by using the term self-defense that what's required is that that's a cross-reference to all of the other requirements of the self-defense instructions. But in fact, the jury instructions on self-defense say the defense of self-defense or defense of others has been raised. And so what the instruction effectively communicates to the jury is that there's no duty to retreat anytime a person raises the defense of self-defense, that you have no duty to retreat even if you're not facing an imminent threat, even if you don't hold a reasonable belief. But Sandoval says, no, actually there are situations, that is a situation where functionally a person would have to remove themselves from the encounter because their lawful option is not to use deadly force in that situation. And so for that reason, the instruction tells the jury too much in that it covers situations, it's too absolute, and it basically says, even in situations where there's a non-imminent threat, a person wouldn't have a requirement to remove themselves from the situation. And that is why this instruction is legally incorrect, or the court doesn't need to even say that. Is it reasonably capable of confusing or misleading the jury? And I think it is. Now, that doesn't mean that there couldn't be a correct instruction. The instruction would have to say a person who reasonably believes that another person is about to use unlawfully deadly physical force has no duty to consider whether it is possible to retreat. That reflects what Sandoval teaches. But when you have an absolute statement that there's no duty to retreat at all, whenever a person raises this defense or whenever a person uses deadly force in self-defense, that's where it runs the risk of misleading the jury.
What about the risk in this case of the jury being confused by the arguments presented by the prosecutor?
So that question alone, this judge stopped writing. I didn't really see her write during was it John Schultz? He kind of pronounced it differently than I would by reading it. He did more Schultz. I say Schultz. So Jonathan Schultz, this attorney seemed to be taking notes when Lindsey Burrow was presenting her arguments. Didn't really see her take notes here. And right out the gate, she's like, well, wouldn't that confuse the jury? Which goes directly to this error, if we find it to be an error, could be considered harmful because it would confuse the jury and thus undermine our confidence in their verdict. So that's a very not good question, I would say, the way I'm reading it. I'm reading the tea leaves from this judge. Not a very good question if you're this guy for this judge to be asking. Yeah, Nem says, yeah, what about being confused? I'm confused.
Well, so I think these are independent issues. So the first, if this is not a legally correct instruction proposed, or it's reasonably capable of misleading the jury, then the trial court didn't err by not giving it. But alternatively, even if it is a legally correct instruction, I think here that we've presented an alternative argument that the instructions given adequately convey the law to the jury. And so I think Harriman takes care of the idea that the instructions themselves would confuse the jury in believing or likely believing that there is some duty to retreat. Now, defendant's argument is that the prosecutor's questions, cross-examination, and in closing argument would have caused the jury to think that the law imposes a duty to retreat. And my position there, the state's position, is that if you look at the prosecutor's closing argument, the prosecutor was not making that point. The prosecutor was saying, look, this was not an imminent threat. Defendant didn't have a reasonable belief that this was imminent. There were 30 seconds that passed. And I understand this is an argument about how to interpret the evidence, but this was the state's position, that the threat was not imminent. So in that time, because the threat was imminent, defendant's lawful options, and the prosecutor uses the term lawful options, were to do something else, were to call 911 or to retreat from the situation. And that's a correct statement of law under Sandoval. What the prosecutor didn't convey is, even if defendant held the requisite reasonable belief and this was an imminent threat, he's still not lawfully justified in using self-defense because he had to consider, whether he could retreat safely. That's the distinction, that the prosecutor can point to defendant's other lawful options when saying, look, this was not a justified use of self-defense because this was not an imminent threat, or defendant didn't reasonably believe it to be an imminent threat. But the prosecutor can't go farther and say, well, even if it was, then the defendant didn't act in self-defense because he failed to retreat. That's where the no duty to retreat comes in.
The problem I'm having with that is I understand the separation of the two issues, but I think they do merge a little bit when you look at the trial court's rationale for denying the jury instruction, which was whether it was reasonable for Mr. Cranston in that situation under all of the circumstances not to have retreated, which I don't think is accurate. And I think it does sort of potentially echo the prosecutor's argument to the jury.
So I would disagree.
I understand the separation of the two issues, but
Sorry. Thanks, guys. Didn't mean to be muted. You guys are so quick. Thank you. So I said, let's run this back. Let's get the verbatim. This judge is giving us a quote from the trial court, a different instruction that the court did give to the jury at trial, which seems to be kind of conveying the opposite sentiment as a special jury instruction that the defense requested, but was denied, and it was not given to the jury. So the defense wanted the jury to be instructed that in Oregon, there is no duty to retreat. Court will not give that instruction at trial, but they give this instead. She quotes it.
The problem I'm having with that is I understand the separation of the two issues, but I think they do merge a little bit when you look at the trial court's rationale for denying the jury instruction, which was whether it was reasonable for Mr. Cranston in that situation under all of the circumstances not to have retreated, which I don't think is accurate. And I think it does sort of potentially echo the prosecutor's argument to the jury.
So I would disagree with you on the last point. On the trial court's ruling, so there's this extended back and forth. I agree it's difficult to parse. I think that parts of what the trial court said were legally incorrect if the trial court was suggesting that a failure of the duty to retreat can be considered if if a person holds the reasonable belief that they need to use imminent force. That said, the ultimate ruling that the trial court made was that this instruction was covered by the other instructions, and then it wasn't necessary and likely to confuse the jury. That's what I'm defending. Some of the trial court's reasoning, I agree, depending on how you understand it, could be incorrect, but that's not a reason to reverse here because the ultimate ruling is correct, and because the trial court had no obligation to give an instruction that was legally incorrect or likely to mislead the jury. Now,
But given that the state had the burden of disproving self-defense, then they also have the burden to instruct the jury if there was an imminent threat on no duty to retreat. It's their job to make sure that the jury has all the instructions.
He buffered here. Listen to him buffer.
Disproving self-defense, then they also have the burden to instruct the jury if there was an imminent threat on no duty to retreat. It's their job to make sure that the jury has all the instructions it needs, correct?
I would disagree that the state has any obligation that when a defendant requests an improper instruction that incorrectly states the law, that the state has any duty to basically respond and provide a legally correct instruction. Certainly, what I would say is, unlike the cases where this court has reversed on plain air grounds because there's been some aspect of self-defense that's been missing, that all of the instructions on self-defense were given. And all defendant is saying is, well, there needs to be a clarification that not that there's another requirement of self-defense, that there isn't another requirement of self-defense. And so this is not a situation where the jury didn't have the necessary instructions on self-defense, like in some of those plain air cases where this court has, looked at whose burden it was to provide the instructions. So that's kind of what that brings to mind to me. And so I don't think in this particular situation where it's defendant's requested instruction that the state had any obligation to do anything more than it did, which is identified to the trial court that it should not give this instruction.
And so just to clarify, the problem with the jury instruction that defendant proposed, which is that Oregon law does not impose a duty to retreat before a person can use deadly force, is that it needed just more words to say in the event that it was not reasonable for them. I mean, what's the problem with the jury instruction?
The problem with the jury instruction is that it doesn't convey to the jury that a person has no duty to retreat only in situations when all the other requirements of self-defense are met. And that's all. And so if an instruction said a person who reasonably believes that another is about to use unlawful deadly physical force, if a person reasonably believes that person has no duty to consider whether it's possible to retreat.
Again, jury instructions come about at the time when the jury is already going through all of the other things that they're supposed to consider. So because they're being asked, if a jury in Oregon is being asked to look at any type of justification for the defense of self or defense of others, they should be considering these factors and whether or not they believe that that was the case, the defendant's case, reasonably in the moment that the incident was occurring. It's baked in. These considerations are already baked in. So why would you need your instruction, your charge to the jury that, hey, there is no duty to retreat? If you find all these other things, there's also no duty to retreat. Why would you need to repeat those other things that are already baked into Oregon's and many other places? Things vary across states, but most states have some, there has to be imminence, there has to be proportionality, different elements defined slightly differently. If it's baked in, why would you need the instruction to say it explicitly? His argument now is not that instructing on no duty to retreat is improper, but that it was improper because it should have been worded more like there's no duty to retreat if, and then repeating the same elements again. He's changing his argument.
And what the instruction conveys is that
So duty to consider whether it's possible, I sort of see what you're saying with the reasonableness piece, but duty to retreat, is it the state's position that in some circumstances there is a duty to retreat?
Yes. In situations where a defendant has no reasonable belief that there's an imminent threat, So defendant cannot lawfully use deadly force. The only other, the only lawful option, or one lawful option, is to retreat. And that's exactly what Sandoval says when it says a person who wishes to escape criminal liability may well be required to avoid the danger if the particular danger is not imminent.
And you disagree with the interpretation that that's referring to the initial
I think
aggressor?
that's not just referring to the initial aggressor instruction. That's one example of a situation where
Okay, so the judges were looking incredulous. The guy in the back here is like, bro, really? And I think he's also with the state. I think the state came from this table. Look at their facial expressions.
required to avoid the danger if the particular danger is not imminent.
And you disagree with the interpretation that that's referring to the initial
I think
aggressor?
that's not just referring to the initial aggressor instruction. That's one example of a situation where there could be a duty to retreat, but the court spoke more broadly to situations where the threat is not imminent. And in any situation where the threat is not imminent, so the defendant is not justified in using deadly physical force, functionally, the law imposes on that person a duty to do something else. Their only lawful option is to do something else. And one of those things, as the court said in Sandoval, may well be to avoid the danger, to retreat. And so when you tell the jury that at no point when you use deadly force in self-defense, that you don't have a duty to retreat, that speaks much more broadly than Sandoval, and it risks confusing the jury. I think that's ultimately the problem here.
Is that true, even though the facts that the judge heard arguably show that there was an imminent threat to somebody at all times during this altercation?
I think that the legal correctness of the instruction needs to be judged based on the face of the instruction. Does this correctly capture Oregon law? And again, I'm not saying that these facts don't support a legally correct instruction on no duty to retreat. I'm just saying that the instruction that was proposed doesn't accurately convey to the jury what Oregon law provides. And in this case, if the court says this is a legally correct instruction, then it's going to be a legally correct instruction in all cases. And that is the particular concern here, that this is a very nuanced and difficult issue to capture. And if it's not captured correctly and with the nuance that Sandoval requires, it can really mislead and confuse juries in this case and in future cases.
I see that you're almost out of time, and I just wanted to ask if you had any response to the arguments in the reply brief on the Chitwood issues.
So on the Chitwood issues,
So the Chitwood issues are in reference to the allegations of prosecutorial misconduct that were also raised as an enumeration of error that we're not really going to get addressed.
I think we fully covered the vouching question. I mean, I think the case law at the time of briefing, and it's been developed since, basically says that if the arguments are tied to the evidence, that arguments about credibility are permissible. We've laid out in the brief why these arguments are tied to the evidence, and also this court needs to look at the context of those. The arguments as to denigrating defense counsel or the other arguments, we think in context those arguments are proper and were also grounded in the evidence, and to the extent that they weren't, that this is a case where a curative instruction easily could have addressed any problem, and I think this fits comfortably within this court's case law. The 40 or more cases where this court has said that particular comments that are claimed as improper can be cured with an instruction on plain error review. I see that I'm out of my time. We ask that this court affirm. Thank you.
We get a rebuttal from Lindsay Burrows. She's ready.
The state's position as to the self-defense instruction is that there is a duty to retreat if the person's not lawfully acting in self-defense. And that is not, in dispute. The reason why the instruction is needed is because the jury could draw the opposite inference. And, to Judge Kamen's question, the trial court did. The trial court made the same mistake that the jurors certainly reasonably could have made. And that mistake is that the jury could have said, okay, we find that the state failed to meet its burden to disprove the elements of self-defense beyond a reasonable doubt, including the imminence requirement. But defendant had other alternatives available. And again, that is the direct teaching of Sandoval. Sandoval says that there is a right to meet force with force in self-defense. There is no duty to retreat if the elements of self-defense are otherwise satisfied. And I think that is really the sticking point here. The state wants, in order for there to be an instruction, I guess, for all of the elements of self-defense to be restated in the requested instruction, that the requested instruction had to say, and don't forget, you still have to find imminence, and don't forget, you still have to find the defendant wasn't the initial aggressor. But of course, the jury's already instructed on all of those things.
But then what does that footnote in Sandoval mean?
Right. The footnote says that, I think exactly the point that defendant is making, that if there is no imminent threat, maybe there's a duty to retreat, there is no self-defense. So, potentially the jury could use the same evidence that we're talking about for the quote duty to retreat or not, like the amount of time, the 30 seconds, was it enough time to disprove, to try to say there was enough time to go to the imminence. But certainly, I think the risk and the reason why the instruction is needed is to clarify that if there is an imminent threat, then there is no duty to retreat, right? And the imminence is baked into the self-defense statutes and the uniform instruction, which defendant requested and the trial court gave. So really, there's no question.
It's in the legislation in two ways.
There are other circumstances where the court has to hear predicate facts before it can give an instruction, right?
Yes, Your Honor.
Less satisfactory evidence, things like that.
Right.
So it would have to make some sort of prejudgment about whether there was an imminent threat to decide whether to give the duty to retreat instruction or not.
No, I think, the point, and I think actually Harriman does speak to this idea. The point is that the instruction is necessary when the uniform instructions are necessary to clarify a point of law that the uniform instructions don't otherwise require. And that will be, I think, to some extent based on the fact it's, just this court's general standard for whether a requested instruction is required. There has to be a factual basis for it. And in this case, there was a factual basis for it, again, because of the prosecutor's questioning and argument. And, as the state says, potentially the jurors could have used it as to imminence, but the risk is that the jurors could have said there was an imminent risk of threat to Mr. Cranston. The state failed to disprove that, if it accepted defendant's testimony, but there were couldn't he just have walked away, which is the way that the state framed it. So that, again, is why the instruction was required in this case.
Do you have any follow-up to the argument that it was confusing or would have confused the jury just in terms of how it was phrased?
No, I mean, the phrasing is clear and, succinct. It's Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. So again, the instruction is saying there still has to be self-defense. The person has to actively be lawfully acting in self-defense in order for there to be no duty to retreat, right? That is the point of this.
But it wasn't incomplete or?
No, because we have the uniform instructions. I think, if this was
that and worked
right
in conjunction with it.
Defendant would not, it would be confusing if this was the only instruction that defendant was asking for, right? Saying like, look, the jury only needs to hear about duty to retreat. Of course not. The jury hears as an element of self-defense that the state has to disprove beyond a reasonable doubt that the threat was imminent. So that, I think, that answers the state's point in defendant's position. I see my time is up. Thank you.
The case is submitted and we're ready for our next case.
So there is the end of the oral arguments on that issue. Before we get back over to the analysis, which I think is going to be a great read, we also get some transcripts in their opinion of the prosecution arguing this at trial. I want to show you the docket for this appeal. So this is just for the appeal. It's not the trial court docket. And again, this is the most recent. So we have their opinion come down on the 29th. But if we go to the first result, guys, we're going all the way back to March 27th, 2023. So just for the context, putting it into a frame of reference of how long it took in this particular case for Lindsey Burrows, for Jonathan Schultz to be arguing this in court. They argued back on September 9th this year. and then for the opinion to come down at the end of the week last week, published yesterday. That's the gap in time and space. So if you're ever in a situation, excuse me, if you're ever in a situation of self-defense or defense of others, some type of justification, not only do you have to go through all of the motions, you could file a motion for immunity from prosecution, saying, hey, look, this was self-defense. And maybe at that level, the district attorney will decide, hey, you know what, we're not even going to take this to trial. We think what you did was a lawful use of force. We're not even going to take you to trial. That doesn't always happen. You go to trial. You've got to wait for your day in court. You've got to wait to have your trial. You get tried. If you're convicted and you still want to continue to fight for your innocence, this is a good look at how long even the early stages, the early mechanisms available for you for an appeal can take to play out. So, and again, his sentence was 10 years for the manslaughter, the unlawful use of the weapon, and the assault charge that he was convicted of. But I think he was denied bail bond, so he's probably got over 3 to 4 years time served already. So imagine everything's completely overturned. He ends up either acquitted at a second trial or they decide not to retry. That's still, in situations like this, people losing years of their life behind bars. The other consideration for that is, especially depending on your state, because I do think if the assistant attorney general was making arguments in a state where there is a duty to retreat, his arguments would have made more sense. The court's instruction or decision not to issue the instruction obviously would be more in line with the legislation in a state that does not say that there's no duty to retreat. Right? But here in the context of Oregon, based on what it seems like there's statutes, there's more than one statute that's reiterating, no duty to retreat. Wasn't really an argument aligned with the case law. We'll get over to their analysis, but it always scares me in any self-defense. I know there's a viral story right now. I think it's outside of a shopping mall where it's a woman. It looks like the brother, and she's off camera, but it looks like her brother, and then she's presumably following behind her brother, are walking towards a shopping mall. And then there's like two guys standing outside already, and another individual gets out of a car, and it looks like they start jumping the brother. And the woman goes and gets a firearm, and she's standing and she fires shots at the individuals while they have her brother on the ground. And she's arrested. She's been denied bond. And seeing that story go viral just has me thinking, like, what would you do in that situation? In that moment, what do you think is reasonable for you to do? Because if someone has my brother on the ground, I feel like I can't get in and fight, or I'm going to get my head pounded on the pavement. That's really dangerous. A physical assault, even if someone doesn't have a knife or a firearm, if you're on the pavement and you could get your head bashed, that could be fatal or cause serious injury, permanent, debilitating injury. And so when I see stories like that, I'm always like, well, dang, like, what would I do? Would I do the same thing? And no matter if you think it's reasonable, if you agree it's reasonable, most of the time it seems like you're going to be taken to trial and charged either way. And you've got to wait years for your destiny to be decided. So it's always a scary decision. Always a scary decision. And I've got to look into it more, Bailey's, but same thing. I saw a video on it and I'm like, oh boy, oh boy, oh boy. And again, with this trial, maybe a different jury in this case that we're looking at with Ian Cranston would have convicted on all counts, would have convicted on the top count and not the lesser of manslaughter, and then the rest down the line. Maybe a different jury would have acquitted. Maybe with the instruction, the verdict would have been different. You just never know. And again, I think we're only getting an issue here because Oregon has said, look, we're not a duty to retreat state, but I don't think we'd even be here in certain other states. I had pinned this, Peter Steele, in reference to the state's argument. He's painting all self-defense cases with the same brush. Surely it depends on the evidence. To me, his argument, I look at, are the elements of justification met That's for the jury to decide. That's a fact for the jury to determine. And the argument that he was making by like inserting an instruction about suddenly there should be a consideration for a duty to retreat. It's almost like taking the fact finding away from the jury on the reasonableness, because you're kind of pushing them to say, well, he could have retreated. And I think more so because this case involves use of a firearm against an assault where someone is, pushing and then striking with a fist and not using a weapon themselves. So I think it's additionally confusing to the jury because the argument seems like bringing a gun to a fist fight, which seems unfair when that point's hammered over and over and over to you. And it kind of waters down the, justifiable use of force can come into play when there's a threat of serious bodily harm, not just somebody else also has a firearm. So let's get into the analysis here. We've got, let's see. I think we were right at here. So let's get this preceding paragraph so we get recontextualized in this opinion. The court declined to give defendant's requested jury instruction, reasoning that the jury could consider whether defendant's decision not to retreat was reasonable under all the circumstances, and that the requested instruction, quote, misleads the jury into thinking that a person has no requirement to retreat. The jury found defendant guilty on all but the second-degree murder count, and this appeal followed. So they cite this case. We review the denial of a jury instruction request for legal error. That's State v. Horn Garcia. A trial court must give a jury instruction requested by a party if the instruction correctly states the law, is supported by the evidence when viewed in the light most favorable to the requesting party, which would be the defendant, and another instruction does not adequately address the issue. That's from State v. Ashkins. A party is generally entitled to have a supplemental instruction given when the existing instructions, read as a whole, do not fully cover a necessary legal point. State v. Worsham, but is not entitled in every case to a special instruction that is tailored to the particular facts at issue, from State v. Roberts. So still, a trial court may err in failing to give a supplemental instruction if that instruction clarifies a word's ordinary meaning or a common misconception imposed by our case law. In the end, what matters is whether the requested instruction is necessary to adequately inform the jury of the applicable law or to avoid confusing or misleading the jury. Our starting point is the language of the self-defense statute. So we heard Lindsay Burrows talk about, I think, both of these. So we've got the Oregon rules here, 161.209 and 219. The physical force statute, 209, provides that subject to certain limitations, including the limitation in the deadly force statute, 219, says a person is justified in using physical force upon another person for self-defense or to defend a third person from what the person reasonably believes to be the use or imminent use of unlawful physical force, and the person may use a degree of force which the person reasonably believes to be necessary for the purpose. So 209, we've got the deadly force statute as relevant here, limits the reach of the physical force statute as follows. A person is not justified in using deadly physical force upon another person unless the person reasonably believes that the other person is 1, committing or attempting to commit a felony involving the use or threatened imminent use of physical force against a person. So this would be like if the other party was assaulting somebody. So like a felonious assault or threatening to do so. They skip, it looks like subsection 2, and they go to 3, to quote 3, using or about to use unlawful deadly physical force against a person. The uniform instructions given by the trial court essentially tracked that statutory language. We've got a footnote. The trial court gave the following instructions on self-defense. So this is a quote from the instructions. Defenses, physical force, defense of person. The defense of self-defense or defense of another person has been raised. A person is justified in using physical force on another person to defend himself or another from what he reasonably believes to be the use or imminent use of unlawful physical force. In defending, a person may only use that degree of force which he reasonably believes to be necessary. The burden of proof is on the state to prove beyond a reasonable doubt that the defense does not apply. And then we're back to the court's analysis. So, as mentioned, defendant requested a special instruction relying on State v. Sandoval, that Oregon law contains no duty to retreat before using deadly force. On appeal, the parties dispute whether that is an accurate statement of the holding in Sandoval. Defendant also contends that the instruction was necessary to dispel the false belief, argued by the state, that defendant had some duty to retreat. The state argues that the instruction is unnecessary and fully covered by the instructions that were given, and any error is harmless. So here's their analysis. We begin with whether the requested instruction, advising that there is no duty to retreat before the use of deadly force in self-defense, is accurate, which requires an examination of Sandoval. In Sandoval, the defendant shot and killed the victim following a driving altercation on the road. So a road rage. I feel like not a day goes by where there isn't like a road rage story in the news. I just got to keep on driving. I don't even want to deal with it. Like, that's so scary to me how many people get caught up in road rage incidents. Like, if you want to cut me off, you've got it. The defendant argued that he acted in self-defense. The state's theory, so this is in Sandoval, was that the defendant provoked the victim, trained a rifle on him until he reached for his gun, and then shot him in the head. At the close of trial, the court gave a series of jury instructions that were drawn from the Uniform Criminal Jury Instructions, and mostly tracked the language of self-defense statutes. So they quote, this is all in Sandoval. Limitations, defense of person, deadly physical force. There are certain limitations on the use of deadly physical force. The defendant is not justified in using deadly physical force on another person unless he reasonably believed that the other person was committing or attempting to commit a felony involving the use or threatened imminent use of physical force against a person, or using or about to use unlawful deadly physical force against defendant or another person. So those instructions were, quote, a person is justified in using physical force upon another person to defend himself from what he reasonably believes to be the use or imminent use of unlawful physical force. In defending, a person may only use that degree of force which he reasonably believes to be necessary. Another quote from the instructions, the burden of proof is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. And this burden actually varies in different states when you raise an affirmative defense. So there's different implications of how the burden is defined, and it can have different impacts at different stages of the trial. Like, requirements for you to raise an affirmative defense might have certain thresholds in Oregon compared to Ohio, and likewise. So very, very complicated. So if you are not in Oregon, please don't take what we're looking at here to necessarily be applicable in your state. Check your own laws. They skip a section here. Then they say, quote, there are certain limitations on the use of deadly physical force. The defendant is not justified in using deadly physical force against another person in self-defense unless he reasonably believed that the other person was using or about to use unlawful deadly force against him and or committing or attempting to commit a felony involving use or threatened imminent use of physical force against a person. Quote, and I think the footnote's going to keep going on the next page. Even in the situation where one of these threatening circumstances is present, the use of deadly physical force is justified only if it does not exceed the degree of force which defendant reasonably believes to be necessary in the circumstances. So there you go. There's some quotes from the trial court jury instructions in Sandoval. So let's see. Back to the analysis, we have over defendant's objection. The court then gave an additional special instruction that the prosecution had requested. Quote, the danger justifying the use of deadly force must be absolute, imminent, and unavoidable, and a necessity in taking human life must be actual, present, urgent, and absolutely or apparently absolutely necessary. There must be no reasonable opportunity to escape, to avoid the affray, and there must be no other means of avoiding or declining the combat. So, now this is the Court of Appeals analyzing the holding in Sandoval, and it's quoting the trial court's instruction within the appeal for Sandoval. So now this appeals court for this appeal is saying that instruction was not based on the self-defense statutes, but on language taken from a prior Supreme Court opinion, State v. Charles. In Charles, the court held that a defendant who killed a person in a street fight was not entitled to a jury instruction, stating that there's no duty to retreat. The issue before the Sandoval court was whether the instruction that there must be no reasonable opportunity to escape and no other means of avoiding the conflict accurately stated the law as it pertained to self-defense. Construing the self-defense statutes, the court first observed that the deadly force statute contains no specific reference to retreat, to escape, quote, other means of avoiding a deadly confrontation, or some similar duty. The court also explained that while the physical force statute used the word necessary in the phrase, quote, the person may use a degree of force which the person reasonably believes to be necessary. That pertained only to the degree of force used and did not suggest that a decision to retreat might be necessary in some circumstances. So I think right here, this might be the distinction that we saw the Assistant Attorney General John Schultz miss. Right? This is a pretty big clarification. That this contextualization with the word necessary is only the necessary degree of force and not necessary to make a decision on whether to retreat or not in the moment that something's happening. The court also noted that the, quote, imminent requirement in that same statute, justifying the use of physical force from what is reasonably believed to be an imminent use of unlawful physical force, pertains solely to the timing of the threat, not the nature of the threatened person's response. The court concluded that nothing in the plain text of the self-defense statutes suggested some duty to retreat before using deadly physical force in self-defense. Well, so far in this analysis of Sandoval, oh, and I have this banner up, my bad. Seems like in this appeal, the reanalysis of the holding in Sandoval seems to lean towards what Lindsay Burrow was arguing. Accordingly, the court held that the legislature's intent was clear on the face of the deadly force statute and did not create any additional requirement, including a requirement that there be no means of escape, notwithstanding the requirements in the self-defense statute that the threat be imminent and the degree of force be that which the person reasonably believes to be necessary. Thus, this is a quote again, the legislature did not intend to require a person to retreat before using deadly force to defend against the imminent use of deadly physical force by another. Now, we're going to go back to the regular case, but do you see how much of this analysis is a recitation of quotes? They're really not doing that much analysis. They're repeating the holdings, the opinion in the Sandoval decision. Really wasn't that much analysis required to see what Sandoval actually said. Although during oral arguments, we heard the state trying to argue functionally, if we look at Sandoval the way I want to look at it, functionally it could mean that you might be able to do this other thing. And here, these three judges are just dropping the quotes from Sandoval, which to me suggests they did not think that that was a convincing argument from the Assistant Attorney General there. So let's turn back. So the requested special instruction at issue reads, quote, Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. That is an accurate statement of the law as explained by Sandoval. So remember, if you're requesting a jury instruction, it has to accurately reflect the law. They're saying it meets that prong. They've got a footnote here. Although Sandoval involves defense of self, the self-defense statutes apply in equal force when defending another person. So if we go back to 209, statute applies for self-defense or to defend a third person. In 219, the statute applies to defend against reasonable belief of certain felonies or deadly force against a person. And I believe the order of operations in this incident was the defendant gets punched, he kind of steps back, and then he's with his fiance and another friend that they went out with. Smith is the last name of the third person, the friend. And now Smith is getting hit in the face. So that's how it shifts from a self-defense moment to presumably defense of others, meaning Smith in this case. There are no, quote, additional requirements, such as a duty to retreat before using deadly force in self-defense or defense of others. There are only the requirements imposed by the plain text of the self-defense statutes. In arguing that the instruction is inaccurate, the state points out that the instruction fails to account for those situations in which a defendant does not, quote, reasonably perceive an imminent threat, citing a second footnote in Sandoval. The state argues that there could be some situations where a defendant may have a duty to retreat to avoid danger. Quote, if a particular danger is not imminent, a person who wishes to escape criminal liability may well be required to avoid the danger, rather than to seek it out and cause that danger to become imminent. And then in parentheses, we have self-defense is not available if accused was initial aggressor. But the scope of the statutes that we consider here applies only to dangers that are imminent. That argument is unpersuasive for several reasons. First, defendant here was not accused of being an initial aggressor. Indeed, the parties agreed that B was the initial aggressor of the altercation, so B is the deceased in this case. The parties agreed that B was the initial aggressor of the altercation when he punched defendant. Second, far from announcing a freestanding, quote, duty to retreat rule in certain types of self-defense, that footnote states only that, when confronted with non-imminent dangers, a person might be required to avoid the danger, such as in the circumstance of an initial aggressor. In addition, this is interesting because imagine this went in the other direction, right? Imagine if the deadly force occurred in the opposite direction in this case, and it was B that was standing trial. This analysis would seemingly be applicable. In addition, the limitations that the state mentions were fully covered by the general self-defense jury instructions already provided, explaining that a person acts in self-defense only if they reasonably believed that the other person was committing or attempting to commit a felony involving the use or threatened imminent use of physical force against a person, or using or about to use unlawful deadly physical force against defendant or another person. The proposed special instruction did not need to repeat every element of self-defense or defense of others to be correct about the absence of a duty to retreat. So remember, part of the argument when we heard the Assistant Attorney General shift his argument, he was like, well, okay, the instruction wasn't inaccurate, it wasn't improper, but it needed other context. So if the trial court were to give the instruction, the defense should have requested that the instruction said, there's no duty to retreat, and it must be this, and it must be this, and it must be this, repeating the elements already outlined above as part of the requirements for a finding of a justifiable use of force for self-defense or defense of others, already laid out in the previous parts of jury instructions. So we saw the state shift their argument there, and now the appeals court's like, they don't need to repeat all of that. They do not need to repeat all of that. If the jury concluded that the state had proved beyond a reasonable doubt that the defendant or Butler or Smith did not face those imminent threats from B, then the jury would follow the court's instructions and reject the defense of self-defense. So we wouldn't even need to question a duty to retreat because the whole justification would have been rejected. They cite here State v. Dowd, presuming that the jury follows the court's instructions. Well, that might be another monster. Defendants' requested instructions simply would have told the jury, correctly, that it could not use the fact that defendant did not retreat as a reason to reject the defense. In the end, we look to the state's arguments, evidence, and jury instructions as a whole, in the light most favorable to the defendant, and conclude that the state instruction was required as a matter of law. So they cite here State v. Harriman, where the trial court did not err in giving uniform instructions on self-defense and declining to give special instructions on no duty to retreat when the defendant identified nothing in the instructions, arguments, or evidence suggesting that the jury would be inclined to think, erroneously, that there was a duty to retreat. So, had the prosecution at the trial for Cranston not hammered this point home when questioning witnesses, not hammered this point home in closing arguments, not hammered this point home every time they played the video clip slowed down, and we heard the one judge ask, didn't they play that video over and over and count the seconds over and over? Then this wouldn't necessarily be an issue because it wouldn't have been confusing to the jury. It wouldn't have been emphasized as a major factor for consideration incorrectly. And this is where it's distinguished from State v. Harriman, where that didn't occur. So court's like, hey, you made it a relevant issue improperly. They cite here also, I guess this is also from Harriman, that a single statement made by a prosecutor during closing arguments that noted both parties' failure to de-escalate the conflict did not interject the issue of whether there existed a duty to retreat in the altercation that followed. So there they found it was harmless. It was harmless. The record here shows that the state returned several times in its case in chief, and when cross-examining defendant, to the idea that defendant could have or should have retreated. The state interjected the issue when examining Butler. Now, I think that's the fiance. So you see what's happening here. The Court of Appeals says the judge made the mistake, the trial court made the mistake. They should have given the instruction. They didn't need to give the instruction with extra context. They could have given the instruction and should have given the instruction exactly how the defense requested it. But now they're taking aim at the prosecutor's behavior without actually making that where they're laying their chips down. But they're going to criticize the prosecution without it being the direct reason for a reversal. So here we get some transcript, you guys. This is the prosecutor doing the questioning at the trial level. During the time when B, the decedent, when B was becoming increasingly aggressive verbally, would you have felt comfortable in that situation if defendant had just turned and walked away and left you to deal with that situation by yourself? Butler: no, I wouldn't. Prosecutor: okay. The state also interjected the issue on its redirect of Smith, defendant's friend. Prosecutor: the three of you could have jumped on B, but you didn't. 3-on-1, right? Smith: no audible response. Prosecutor: fair to say? Smith: that could have happened, yeah. Prosecutor: that could have been one of the options, right? Correct. Could have called the police instead? Correct. Could have just grabbed defendant and walked away? Smith says, at that point, I did not want to turn my back on B. Prosecutor: okay, you could have backed off, yes? Smith: correct. Prosecutor: okay. And the Court of Appeals here is emphasizing this one line: could have just grabbed defendant and walked away. And you could have backed off. So they're emphasizing all of the hints at duty to retreat that doesn't exist if the jury finds overall that the other elements of self-defense are in play. So back to the analysis. The state also interjected the issue when cross-examining defendant, because the defendant took the stand in this trial, Cranston took the stand, by strongly implying that defendant should have retreated when the argument with B began, and that defendant should have retreated after B punched him. Prosecutor: instead of knowing that you have a handgun, knowing that you could have been the bigger man, and turned and walked away, you didn't, did you? Defendant: and leave my fiance with this man? Prosecutor: you could have grabbed her and said, hey, let's go. Couldn't you have? Defendant: again, it didn't cross my mind. I didn't think that it would escalate to the place that it did. Prosecutor: you didn't think it was going to escalate, but you're using the F words. B is using the F words, and you think he's flashing gang signs. Mr. Smith is starting to yell, as well as using profanities. So you didn't think it was an option just to be the bigger person and turn and walk away. Is that correct? Defendant: no, I wouldn't say it that way. No. During an exchange about the moments after B had punched defendant and before defendant shot B, the prosecutor again suggested that defendant should have retreated. Prosecutor: so you knew the reaction of B. He saw that you had a handgun. It fired him up even more, but you didn't walk away, did you? No, and then there's 3 asterisks. Maybe they just put 3 and it's a longer word. I would imagine it's like, it effing scared the shit out of me. We don't censor shit. Okay. All right. But this is apparently how the transcript wrote it down. It scared the shit out of me that he didn't seem to care. Prosecutor: okay, did you grab Allison Butler, your fiance, your beloved one, and say, hey, let's go, this guy is crazy? No, I did not. Prosecutor: did you say anything to Tyler Smith, like, hey, let's get out of here, this guy's not even paying attention to the handgun? And it says no, and then there's asterisks. So what does it say? Like, no shit doesn't really make sense. I don't know what that curse is supposed to be because it kind of doesn't make sense, but okay, there's a curse there that's asterisked. And then we're back to the analysis. And the prosecutor reminded the jury of this line of questioning in the state's rebuttal closing argument as part of the final argument that the jury heard before it went into deliberation. So I actually kind of like this. I didn't pay attention to this when I looked through this, but they're emphasizing that with the rebuttal, you get the last word. There's no chance for the defense to get up and through their closing argument, push back on the argument that you're making. It's the ring that they're hearing last. So I like to see the Court of Appeals emphasize the impact that that could have. And this is from that rebuttal argument. The prosecutor says, I asked him about 911. I did ask if they could have, ganged up on him. I also said, why not just leave? Remember that? Under those circumstances, defendant's requested instruction was required. Given the emphasis that the prosecutor placed on defendant's failure to leave the situation, the jury could have believed that the defendant had a duty to retreat. There was no jury instruction that, quote, adequately addressed the issue of a non-duty to retreat. Thus, defendant's special instruction was required. They say, see Roberts, that a special instruction required to clear up common misconception of the law imposed by case law. So finally, the error was not harmless. In assessing harmlessness, we look to whether there is little likelihood that the error affected the verdict. In doing so, we consider, quote, the context of the evidence and record at trial, including the parties' theories of the case. Given that defendant did not dispute that he shot and killed B, the sole issue at trial was whether the defendant was justified in using deadly force. Determination of that issue required the jury to evaluate defendant's beliefs at the time he pulled the trigger and whether those beliefs were reasonable. The trial court's error went directly to that key issue. Without defendant's requested instruction, the jury may have incorrectly assumed that defendant had some duty to retreat when rejecting defendant's assertion of self-defense. Thus, there is more than a little likelihood that the error affected the jury's verdict. It's reversed and remanded. So we did it, chat. We went through the whole analysis and the oral arguments. So I imagine prosecution's probably going to want to retry this. He cannot face the top-level charge. He was acquitted of that. But I'm sure all the other stuff will be on the table. I think there was one unlawful use of a weapon. There were 2 charges, and the jury seemingly acquitted on 1. So he wouldn't be able to be retried on that second. Maybe that was for the brandishing. And then the one that he was convicted of was for the actual firing. It was 1 bullet. And unfortunately, that 1 shot was fatal. It was a torso shot, I believe. So, but yeah, if they decide to retry, top level count there is the manslaughter. And it seems like he's already served about 3.5 years. So we got Adventure Aaron in the building. Good to see you. We were talking earlier about getting nervous and buffering while making oral arguments because the assistant attorney general seemed to be a little stumped during oral arguments. Yeah, Mavka, he just sits until a retrial. Yeah, he was never given a bond, but maybe they'll renew. I don't know how the different factors play out in Oregon as it relates to fighting for bond, but I think it's a bigger hurdle when someone's facing a second-degree murder versus a manslaughter. I would imagine that there will be a motion for reconsideration of bond. And now there's different allegations, right? So who knows? Maybe the decision will go differently if that motion is renewed. Secondly, if this goes back to trial, what the appeals court isn't saying here is, we think he's innocent, free him, or we think somebody's guilty, don't free them. Here, and sometimes I read certain appeals decisions where it just seems like they're not listening. Appeals courts aren't even listening. Maybe they do have a conclusion in the back of their head, and that's steering them. Here, it just seems like, look, the jury could have sat there and said, you know what, if I was in their shoes, we heard them slow it down. We saw them slow it down. We heard them count the seconds. And I'm imagining how long that was that I would have been able to make a reasonable decision. And I think I would have just walked away. So they're saying it could have impacted, more likely than just a little bit, had an impact on the jury's decision-making process. But a new jury at a new trial could come back and deliver the same verdict that this jury did, even with the proper instruction given next time around. So you just don't know. I have no idea where this is going to go. But at the end of the day, it's really laughable to see a prosecutor make an argument that even though there's no legal issue or issue with the accuracy of the requested jury instruction, it was like a one sentence, court sided with the prosecution. And now we've got this court of appeals saying, well, the trial court erred. And really, the prosecution's argument was flawed too. So the direct decision isn't based on the prosecution messing up. It's really the finger wagging is at the trial court, not the prosecution. But the trial court followed suit with what the prosecution wanted. And I just like to see that. I just like to see that. Yeah, Peter Steele, that is a scary prospect because 10 isn't the max. And again, it was more than one charge. Although I think some of the lessers, the sentencing was consecutive on the lessers. But a great point here, and this isn't just with this case, it could be anywhere that the sentencing timetables allow. If he's tried again, he can get a longer sentence than the 10 if found guilty. So there's a risk. There is a risk. So who knows? And we never got, you see, there was nothing, we had a footnote that said we're not addressing the other issues. So we only got to hear briefly that there are allegations of prosecutorial misconduct. It seems like there was some vouching at issue. Based on oral arguments, it seems like the prosecution during closing might have tried to vouch for the credibility of one or more witnesses, or at least part of what one or more witnesses said. And the prosecution's defense to that was, well, the evidence also supports the vouching that we did for the witness. So it's not really a proper argument. But I'm not sure, based on the judge's curiosity on the issue, that at a first reading of the appeal briefs, the judge was entirely dismissing that argument, but they chose not to address it here. So, yeah, so Mavka, and maybe we should talk about this, guys. There is no big news in the Alicia Andrews trial. On Saturday, I posted really just to show that YouTube comments were being used as an exhibit in a motion that was already filed and decided. It was denied on Friday. So before closing argument started, the defense had filed probably early that morning a motion to disqualify Judge Michelle Cisco. Judge denied it. We heard that orally. So if you're watching the feed with us, it was really brief after one of the breaks. But the judge said, I'm denying your motion to disqualify. And then they carried into the next order of business. So that it's a moot issue. There's not like a big issue where the verdict comes back and in this post-conviction space, the judge suddenly is at risk of being disqualified. It's really a moot issue as far as that motion. It was denied for lacking a sufficient legal basis, and there's a verdict. So I think it would go nowhere if they tried to file such a motion right now. Maybe we'll see the argument included as part of some appeal initiative, but I certainly hope it's not their main argument for appeal. If they want to appeal the manslaughter conviction, they should really be arguing the potential issue of including those lessers at all, based on the judge's ruling where, if you want to bring in evidence of domestic violence, the defendant has to take the stand herself, and then I'll include these lessers. We heard her express concerns about that on Friday, but she didn't want to go back on her previous ruling from a motions hearing the day before trial started. So that's nothing new, and it's moot. It's dead in the water. So, but I did share that over on X. Let's see. And you'll see some familiar names. If you guys know Coco, if you guys know Tall Glass, they made it into the record here as an exhibit. It's real quiet over here, but Tall Glass is right here saying grounds for an appeal. I'm so glad this is on the record. And it's really, these are all screenshots from the Law and Crime chat. So that's where they pulled these all from. And if you guys want to read the full motion, calling it motion to DQ. Actually, that link gave me a Twitter redirect. So there you go. But yeah, I didn't mean to start any like scary news. I should have put it in the original post. I would have put it in the original post if I had realized it'd be confusing. I had to do it as a reply. But I didn't realize people would interpret this as being a new, like a filing after the verdict was reached. By all accounts, I think the defense should be satisfied enough that the verdict wasn't the top level. And if they have an issue with the manslaughter, they should appeal it in regards to the decision on the choice to include it the way that the judge agreed to include it. The judge seems to have reservations about that herself. So the other thing, one more thing, we're pretty much going to keep these focused on one short topic. But I saw this story, it pissed me off this weekend. I couldn't believe the odds of it. We had a story of a Black grandmother says Georgia deputies wrongfully arrested her on white woman's charges. And when I looked into it, I had to look across a few articles. The last name Sledge. So you guys know Munktunk. He's Antonio Sledge. He was confused with an Anthony Sledge, totally different person. And we heard the probation officer read off charges as if they were Antonio Sledge, Munktunk's charges for like sexual battery. And they're not his charges. They're not his criminal record at all. So another Sledge, we have Nikki Sledge, who's pictured here, who's 49 from Georgia, was arrested in the presence of her family members for elder abuse and all of these like very despicable type charges, like abusing the elderly. When the person they were supposed to arrest is Nikki Sledge with a different first name spelling, 43 years old and from Kentucky, lives in Kentucky. And it's elder abuse, so the victim, I forget the guy's name, but it was like a grandfather relationship. The name was known. Totally different family member name. Nikki Sledge doesn't have a family member with the same name. Doesn't have someone with that name in a like grandparent relationship. All of these things wrong, totally different state. They arrest the wrong woman. The wrong Sledge specifically. So I saw that this weekend as well. that was a what in the moment as well. I would like to see her get some type of compensation for what she went through. I mean, she was arrested. I think she was in jail for a few days. And it just like where is the checking of basic details? Where is the checking of basic details? Do we even try? No. Used and F2C. And I forget what your regular name is. Says, do elders have a duty to retreat while being assaulted? We're not blurring the issues here, guys. Do they have a duty to retreat? Oh boy. But yeah, I would like to see a lawsuit for her. It's just crazy. Like, I don't get how the state agencies across different states, why were we even looking in Georgia? Like, I don't know. I couldn't believe it. If you guys want to do a little dive on that, let me link to this article here. It was kind of bare bones, the information on this. But for me, I mean, wrong person arrested, totally wrong. It's not like we live in the same town and we're both named John Smith, and that's a common name, and we're like born the same year. We both have, I'm a John Smith Jr. and my grandfather is the John Smith Senior, and the other John Smith also has Senior Johns in their family. Like, it's not that. It is not that. So there's an article with some background context. That link should not be paywalled, so if you want to read it, you should be able to. But yeah, oh my God, LOL is kind of just the reaction there. So, all right, guys, that's gonna wrap it up. What are you guys doing for the rest of the day? It's midday. I don't know if anyone's watching. I know there's like a teen lover murder trial that Law and Crime said that they were starting off. Let's just see who's live and who we can redirect to. I missed a premiere from Amy E this morning, you guys, so I'll be going back and watching that, but I can't redirect to something that's already done. But it's somebody gets arrested, it's body cam footage, and their alibi gets disproven on the spot. So make sure you guys are checking out Amy E. Tons of stuff to keep you busy if you're looking for something to do. Oh, Aaron has an update. Aaron says, I have Kansas City, Kansas. Thank you for specifying which side, which Kansas City. Police Department lawsuits, or Kansas PD updates. A firm that I may or may not be familiar with filed federal lawsuits against Kansas City, Kansas Police Department and the estate of Roger Golubski on behalf of 2 clients. How much coverage is there of that? State lawsuit. Well, generative AI in the search results has a little bit of. All right, 2 men. We have KSHB 41, Kansas City. Let's breeze through this, you guys, while we're here. So 2 men sue KCKPD. Oh my gosh, we're just gonna say KCP. That's a lot. Estate of Roger Golubski for wrongful imprisonment. Roger Golubski has been a name that's popped up quite a bit with issues, corruption issues. Yeah, this might not be the only time we hear his name over on this channel, but as it relates to today, we have Sam Hartle reporting on Halloween. The 2 men have filed a federal civil lawsuit against the unified government, Kansas City, Kansas officials, and the estate of former Captain Roger Golubski for being wrongfully imprisoned in a 2009 double murder case. Oh my gosh, all of these cookie things. Attorneys representing Dominique Moore, 41, and Cedric Warren, 35, filed the lawsuit Thursday in U.S. District Court, District of Kansas. The pair were charged in a 2009 double homicide that they didn't commit. Both were released from prison in December 2024. Geez, so decades after Wyandotte County District Court judge ruled Moore and Warren received unfair trials. Golubski, who died by suicide last December, right before the start of his federal trial, supervised the investigation into the 2009 double murder case. We have Moore saying in a press release that no one should have to endure what I went through. I'm so happy for my freedom, but I want justice and accountability for the more than 15 years that the police stole from me when they framed me. Following the judge's ruling last December, Wyandotte County District Attorney Mark Dupree supported the ruling and declined to refile charges. So always love to see that, right? Sometimes there are cases where it just seems like a no-brainer to refile the charges. And the opposite, it seems like a no-brainer not to refile charges. But when it comes to the cases where prosecutors really, it's almost objectively they shouldn't be refiling charges, it seems like they're just gung-ho to refile anyway because they just want the win. Your win gets reversed, well, we've got to re-win again. So this was I don't remember when we talked about this. I don't remember when this came up, but I remember Aaron was part of the conversation. It might have been on Twitter, actually, and we were replying back and forth. But I remember being surprised to see, hey, we have a district attorney saying we're not going to refile. We're not going to keep going with this. We think the right thing is to this was incorrect. We believe it's incorrect. We're not going to continue to just try to get a conviction on the books. The new lawsuit alleges the pair's 4th and 14th Amendment rights were violated, including their right to be free from prosecution without probable cause and the deprivation of liberty without due process of law. The justice system in Wyandotte County is unjust and unfair in more ways than anyone could ever imagine, Warren said Thursday. I was wrongfully imprisoned for 16 years until my attorneys proved my innocence and also exposed the lying officers responsible for taking my life. The wrongful imprisonment of Moore and Warren is similar to the case involving Lamont. It was on Twitter. I have that. I've been reading that. I only made it through like the first 30 pages. This is why I know it, Aaron. It was on Twitter, and you posted about Lamont McIntyre's story. And the first thing I looked up, like the very first thing I found that came up about Robert Gabolski, whatever his name is, was a hot mess. Like, it did not have to do a deep dive to find something crazy. Let me see what that was. Lamont McIntyre, not to be confused with Jim McIntyre. This should have been when we started doing the what in the, because look at my first words, what? My first look at the wrongful conviction of Lamont McIntyre and what? After 8 years of investigation, the tragedy ran even deeper. Detective Roger Golubski with the KCK Police Department, notorious for his sexual abuse of women in the community, had previously harassed and abused Lamont's mother, causing her to move to get away from him. After her rebuffs, the detective created a 5-person lineup for the double homicide. And that 5-person lineup included Lamont and 2 other McIntyres, 2 other family members. So you have a 3 in 5 chance of choosing someone that this woman's going to care about after she rebuffs your sexual advances. There was one difference between Mitchell's account and Nico Quinn's. Mitchell said the shooter looked like a man who tried to talk to her niece. That man's name, she said, was Lamont. We have a long parenthetical here that says the man who was interested in Mitchell's niece was also named Lamont Drain, though she didn't know his last name at the time, and he was out of town on the day of the murders. And we've got Aaron. There we go. There's where Aaron comes into the picture. So Golubski and the prosecutor, Tara Moorhead, threatened to take Nico Quinn's kids away if she didn't testify against Lamont. Nico, this is the origin of what in the... Nico was the victim's cousin. Moorhead surrendered her license in 2024. Lamont's trial attorney was indefinitely suspended in 2023 after disbarment in 1998 and reinstatement in 2015. The trial judge, who was romantically involved with Moorhead for years before Lamont's trial, retired without consequence. Like, Golubski knew who actually unalived Daniel Quinn and Donnie Ewing. Did you use this to, like, make sure if I ever read it on YouTube, I'd be good? We got unalived. He put Lamont, his brother, and his cousin in the lineup for a couple reasons. One, to get revenge on Lamont's mom, who reported Golubski's sexual assault and moved to get away from him. 2, because he was allegedly trafficking women and girls with Cecil Brooks, the man who ordered the hit on Daniel and Donnie. Multiple state's witnesses, I think this is what this is, who were found unalived had last been seen with Golubski, including Nico's sister, Stacy. Golubski terrified the Quindaro neighborhood of Kansas City, Kansas for decades. His longtime partner, Terry Ziegler, allegedly witnessed Golubski's actions and never reported him. Ziegler retired from his position as the KCK PD chief in 2019. Both are named in ongoing lawsuits. Well, I think there's a new one. Add another to that plural. Golubski and Brooks were federally indicted on involuntary servitude charges. Golubski was also federally indicted on kidnapping and SA charges, so sexual assault. Trial was supposed to start on December 2nd, 2024, but Golubski was found unalived in his home that morning, self-inflicted wound with a stolen weapon. In my opinion, this is Aaron's again, going back to opinion. Golubski played a role in wrongfully convicting 8 men and boys from Wyandotte County, Kansas, at least 5 of whom are immediately related to victims of Golubski's SA and stalking. Lamont McIntyre, John Keith Calvin, Brian Betts, and Celeste McKinney, Cedric Warren, and Dominique Moore, and Ronell and Donnell Williams. There could be more. These are just the cases I personally reviewed. And that's not even the full story when it comes to Golubski, Wyandotte County, and the Justice for Kansas City, Kansas movement. So the movement is so big that they're not tying it to any one person's name. There's so much that they're just saying Kansas City, Kansas. I could literally go on for days. Okay, so this might need more than a what the, or a recurring what the theme. Let's see. Let me also get that book link, guys, if you guys want to get Lamont McIntyre's book. It's autobiographical, so it's going to share his story from his perspective. I know he had a short little website for it. Just a whole mess. Maybe at the end of all of these What the streams, we'll just do like a bonus What the at the end with like one piece of the Kansas City chaos at a time. It'll just be the way we bookend these videos. Let me see. McIntyre, not Jim McIntyre. There we go. Look at our wonderful adventure, Aaron. Trialbylies.com is the name. There we go. Oh, it's the book name. So if you want to check out Lamont McIntyre, his story, there is a link in the chat for that. Or if you're on Replay Crew, it's just trialbylies.com. Coco says, I can't say anything about Kansas. Our Mississippi cops have made national news again, and not for a good reason. We've got a big scandal here in Florida with the Hillsborough Police Department, like flubbing admissions for FBI admissions for the academy. There's a lot going on in Louisiana, too. You guys know I don't have to mention Georgia. I think Georgia, by default, we can assume there's a hot mess going on in Georgia. Let's see. And then Aaron has also linked to several complaints, which we won't get into in deep in this stream here. But they are there in the chat. Thank you for linking those. It's always nice to be able to get directly to the briefs. It was, even though the docket was available for Cranston for the appeal, I had to get the brief from a local news outlet. I mean, the opinion from a local news outlet. I couldn't click in to actually open it with the access that I have as a regular user. So thank you for linking those directly, because it's just, it can be a pain in the butt to get the documents. Yeah, Jaso says, I'm going fishing. Have a good time. Have a good time. Let's see. Always a hot mess in Georgia. See, you guys get me. You guys get me. Aaron is a rock star. So are you, Aaron. EJF Aaron and Adventure Aaron, both rock stars. Pat Stacks just says, shout out Mississippi over in Petal. So yeah, shout out to the good things in all these states, right? I'm not trying to, me freaking out, especially with Georgia, is never a statement of Georgians, right? It's always just, you guys have a lot going on in these different places. It's always just a statement on the crazy stuff that's happening and never on the people that live there. There we go, you guys. Sapphire Ridge News is getting out of here. You guys are cueing my walk-off music. As far as someone who's live right now, we can go and hang out with. What does YouTube give me on the back end? I'm losing my voice after an hour. We've got, that's not a trial. Brother Counsel is doing a rewatch of Casey Anthony, so that's cool, but he's on day 28, so that's kind of in the middle. Broken Baker is live with the Matthew Paul trial. What is it giving me? That's not live yet. I'm surprised I don't see Dolly. So Dolly has a courtroom roulette upcoming, so he's not live yet. I don't see Classy live. Classy has a live that will start at some point on, I think, the Karen Reed civil updates. She had a change of attorneys. She has 3 new attorneys for the civil action. So let's do Broken Baker with the Matthew Paul trial. We can go over there. We got to fight back. Baker always raids us. We're losing. We've lost battles. We still have a chance to win the war. Go over there and punch his like button. Hit this like button too. And say hello, and then hope to see you guys either on one of these soon. Again, either tonight, tomorrow. I don't know the time that we'll do these. They're going to be sporadic. But the next thing I want to talk about is this bad review civil case where a YouTuber is getting sued by like a fitness equipment company The YouTuber was like, hey, for a free product, I'll give you a review. And then the review was negative. The YouTuber says this is like a piece of junk. This is a POS. And then the company is now suing for defamation. So I think we'll take a look at that because it's kind of like, what is this? An honest review that the company just doesn't like? Or are there allegations that the YouTuber used it for free equipment and gave a dishonest negative review? Which way is the cookie gonna crumble? So we'll take a look at that in the next what, unless something else what comes up in between either today or tomorrow morning, you guys. Until then, yeah, Broken Baker is the streamer's name. So that's where we will redirect to, you guys. See you over there, or I'll be hopping around all day. So see you somewhere in these YouTube streets, you guys. Please kindly hit that like button on the way out. And you guys all have a good one. Bye, guys.